Do we have Mr. Humes on Polycon? Probably not, actually.
No, he's 9:30.
That's true. He's 9:30.
We could handle that.
Okay, I'm gonna do this 8:30 sentencing here, and I think that all the parties are here and prepared on the 8:30 sentencing of Brittany Olive. So, my lord. Yep.
I think Baylor. Oh, Olive's here. Carter's in custody. All right. Sally, how are you?
Good morning, Your Honor. I'm doing well. How are you doing?
Pretty good.
Good.
All right, so we're on the record in docket 25-01681. That is City of People, State of Michigan versus Brittany Melinda Olive. Appearances for the record, Mrs. Cisneros.
Good morning, Your Honor. Elena Cisneros on behalf of the people.
Ms. Donnelly.
Assistant Public Defender Sarah Donnelly on behalf of the defendant, Brittany Olive, who is standing to my right.
And ma'am, you are Brittany Melinda Olive, is that correct?
Yes, sir.
All right, thank you. This is the time set for a sentencing in the matter. Mrs. Cisneros, is there any restitution in this matter?
No, Your Honor.
To come to the court's attention?
There is not.
Okay, thank you. Have you been able to go through the pre-sentence report with your client, Ms. Donnelly?
I have, Your Honor, and I have, well, the only addition I would make is that Ms. Olive is employed right now. She works for Michigan State in food prep in the stadium.
So employed, is she fully employed, or is that a part-time position?
It's seasonal.
Seasonal? With that edit, anything else? Any addition, deletion, or correction to the pre-sentence?
No, Your Honor.
All right. Allocution, Ms. Donnelly.
Thank you, Your Honor. We appreciate the court's consideration and time today. In regards to the PSI, we really appreciate the probation officer, Ms. Bayless's comments about Ms. Olive. Obviously, you know, she very much clearly pinpointed the issues here. And in that regards with the mental health issues, Brittany has been a consumer at CMH for a number of years. She recently has basically gotten back into the swing of things at CMH after, kind of not going after a while. So right now she is engaged in services. She has the support of friends and CMH. I've been in contact with people at CMH in her regard. So I believe that a short term of probation as recommended will be very useful for her so that she can learn some of the tools so that she doesn't have to find herself in this kind of predicament again. Thank you, Your Honor.
Thank you, Ms. Donnelly. Mrs. Cisneros, is there anything from the people's perspective that they'd like to argue concerning the sentencing?
No, Your Honor, I think it's appropriate.
All right. Ms. Olive, is there anything you'd like to say to the court before the court passes sentence?
No, sir.
All right. This is for a guilty plea that occurred on June 26, 2025 for 2 attempts of an attempt to R&O. I've had the opportunity to read the pre-sentence report and the overall impression from the probation officer, Ms. Bayless, and I'm completely in agreement with it. So I'm going to order the defendant spend 2 days in jail. Credit is given for 2 days previously served. So you get credit. So there'll be no upfront jail. Okay.
Okay. Oh my God.
We want to clarify that,
Okay.
right? I'm gonna order jail, then suspend it. Okay.
Okay.
So it's spend 120 days in jail upon successful completion of probation, and I'm suspending all that time. Okay.
Okay.
And that's kind of the stick. Okay. That's over your head, but there's no upfront jail.
Okay.
All right. The fines and costs in this matter on a one, the defendant pled to 2 1 years. I'm gonna set fines at $200 fine, $200 costs for a total of $400. Crime victims' rights fee of 75, state minimum cost fee of 50. Probation is for 8 months at $30 a month. I'll give you a total of that. Plus 125, plus 400. I have 765 on the first charge. I'll do that again, 400.
Your Honor, or is it possible that you can waive a fine because she's
On the second charge, but not on the first
Okay,
charge.
all right.
The second charge is gonna be the one that there's some discretion with. The first charge, it's gonna be, it's because she's got 2 1 years. essentially. All right, but so that'll be 400 plus 125 plus 240. I'm just doing it again because technology is wonderful if it works. And then I'm gonna waive the fines and costs on the second charge. I'm gonna waive the crime victims' rights fee. And waive the state minimum court costs on the second charge. That's a complete waiver on that. And there'll be no probation. So on the second charge, it comes down to 0 on that.
Okay.
So it'll be 765 for both charges. Probation for 8 months via Zoom, abide by terms of probation, pay fees and $30 per month. And that's an $80, that's $30 per month for $240, can be paid at the end of probation. No assaultive or threatening behavior, no use of possession of alcohol, marijuana, or controlled substance without a prescription, submit to random PBTs and or urinalysis as directed by your probation officer, who will be, I believe it'll be Jody Bayless. Submit to random PBTs, no bars or nightclubs. It's probably a good idea. The box is checked. So complete following rehabilitative services, pay fees, and provide proof of completion of the court. There's a cognitive behavioral therapy class based on the facts. I think that'd probably be a good idea. I think all of us should take it. Okay. I think all of us could do some anger management classes and cognitive behavioral therapy classes. It's about a weekend. Okay. And that you can do that at the discretion of your probation agent. I don't have anything checked in regards to mental health counseling and sign release, so I'm not going to require that. I'll let that continue on its own course. All right. There are times that we have that checked, and then mental health counseling can be reported to the probation agent. Since you're already caught up since you've been doing that, there's no reason to duplicate it. All right. Not purchase, possess firearms, ammunitions of weapons of any kind, and obtain and maintain employment at this time, which your seasonal employment is fine. All right. All right. So we'll make it look pretty because it's got some waivers on it. Anything else for the record in 2501681, Ms. Donnelly?
No, Your Honor.
Ms. Cisneros?
No, Your Honor, thank you.
All right, Ms. Alt, do you have any questions of me? All right, I'm gonna make this all look pretty. It wouldn't be a bad idea to go down to the 5th floor and check in with Ms. Bayless, just to make sure you understand the nature of what she requires. All right.
Okay.
What's that?
We get Howell brought up. No, I value my life.
You said we, so
The royal we.
send him down there. He can bring them up.
Well, if you guys want to see if this fight happens.
I'm all about popcorn. I would love to see you in this fight.
First.
I know that.
We want Howell judge.
Yeah, we can.
Look, in 5 years, I've only had 2 defendants try and attack me in court.
Yeah.
Yeah. I want to keep it at
Hello.
2. I haven't seen them yet. I may need someone's spot here. I need to make an adjournment request that unfortunately requires video presentations.
Oh, God.
Are you serious?
Yeah.
Why? You're gonna say something you're not supposed to say.
It's always possible.
Yeah. Right, so we're on the record in docket 25-02289. That is people of the state of Michigan versus Nelson Humes. Appearances for the record, Mrs. Cisneros.
Elena Cisneros on behalf of the people.
Mr. Vincent.
Conrad Vincent on behalf of Mr. Humes. who is appearing by Polycom today.
And sir, you are Nelson Humes, is that correct?
Yes. Is it that
And you
my
can hear me all right,
attorney?
Mr. And you, that your attorney's here, yes.
I never met with him, not once.
All right, that's fine. He just got appointed, Mr. Vincent. I just signed the substitution appearance. Are you conflict counsel on this?
I am conflict counsel.
So, Mr. Humes, this has been from the public defender's office. Mr. Vincent just came and was just assigned as conflict counsel. So that would be, I'm assuming that'll be worked into what we're doing here today. So Mrs. Cisneros, how are we proceeding today? Would you like to defer to Mr. Vincent?
Your Honor, it's my understanding the timeline has been previously waived in this matter. I think the court found good cause at a previous hearing when the matter came up that he would need conflict counsel. So I would just ask that the matter be reset for a preliminary exam, given the fact that Mr. Vincent quite literally just filed his substitution of counsel.
Right, I think I signed it. There was some discussion about conflict counsel. I'll let you make a record, Mr. Vincent.
Thank you, Your Honor. I did speak with Mr. Watson yesterday directly, and I accepted the assignment for Mr. Humes, filled out the the appropriate documentation to substitute in. Mr. Humes is correct. I have not met with him, as it was actually probably about 8 o'clock last night. I have every intent on meeting with Mr. Humes and going over his case. I will be receiving the discovery in this matter. I have talked to the prosecutor. Once I receive that discovery, Mr. Humes will get a copy of every bit of it, and I will be meeting with him to go over each and every document prior to any preliminary exam being set.
I would indicate that this has been the grant the adjournment for conflict counsel for good cause was on August 15th. There was some notion that this is going to require conflict counsel, and it did necessitate that. So we will grant the adjournment for good cause concerning Mr. Vincent has just made his appearance. I've just signed his appearance for conflict counsel, and we'll reset this 2 weeks out. You think, Mr. Vincent? Yeah, we'll check with your schedule.
What date, Your Honor?
I was actually going to 3.
Let's try 3.
September 19th at 8:30.
That will work. September 19th at 8:30.
Right. So we'll set it for September 19th at 8:30. We'll schedule it for, I don't know, do you want me to schedule it for PCC or straight to prelim?
I would defer to.
I mean, I haven't met with them, so it's hard for me
Yeah, it's
to
hard
judge
for you.
that.
Well, let's set it for prelim right now.
Okay.
And then if we need for PCC, just let us know. But
Thank you.
I don't want to prolong it any more than we have to.
Thank you. So the preliminary exam date will be the September 19th.
Yeah, September 19th at 8:30 will be the preliminary examination date for subpoena purposes.
Great, thank you.
Thank you. I'll reach out.
Anything else for the record in 20? So I found good cause for the adjournment for conflict counsel appearing, and we set it for September 19th at 8:30. Anything else for the record in 25-02289, Ms. Cisneros?
No, Your Honor, thank you.
Mr. Vincent.
None at this time. Thank
Okay,
you.
Mr. Humes, Mr. Vincent will be out to see you. We've reset the date for September 19th at 8:30. Thank you for
Thank
your
you.
appearance today. We'll see you, Mr. Vincent.
Thank you, Your Honor.
So, Mr. Humes, if they come to you, you can tell them that you're all set with your hearing, okay?
Okay.
Thank you. the city of, people of the state of Michigan versus Jabril McGriff. Appearances for the record, Mr. Pfeiffer,
Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Mr. Sartz.
Good morning, Your Honor. Jacob Sartz, the fourth Assistant Public Defender here on behalf of Mr. McGriff. Mr. McGriff is seated at council table. He's seated to my right.
And sir, you are Jabril McGriff, is that correct?
Yes, sir.
Thank you. This is time set for preliminary examination. It's my understanding that we're running the preliminary examination. Is there anything to come to the court's attention before we get started, Mr. Pfeiffer?
Not on behalf of the people.
Mr. Sartz, and would each party like the court to invoke a sequestration order?
Yes, I'll make that request, Your Honor. I will note that Mr. McGriff's father and his stepfather are in the gallery, but both Mr. Pfeiffer and I have checked. We don't believe either gentleman would be potential witnesses. I would just urge the family, friends, everyone involved, is please not discuss the testimony that was observed today.
Is that a fair statement, Mr. Pfeiffer?
That's correct, Your Honor.
All right. And I will wait to hear from counsel if anybody comes in the court that shouldn't hear another witness's testimony concerning this matter. I will invoke the sequestration order and wait to hear from counsel. Anything else to come to the court's attention, Mr. Sartz?
Thank you, Your Honor. I expect the prosecutor will be seeking to introduce evidence pursuant to 768-27C. Your Honor, I would just state that I'm going to have a continuing objection to any of those statements coming in. And if Your Honor would like, I can make my basis for those objections now, or I can just make those objections at the time when the prosecutor seeks to.
At the time that the prosecutor seeks to enter those hearsay statements or purposes of prelim, you can make the objection. It'll be an ongoing objection.
I will just note briefly my client's position on this very clearly. He would request this case be dismissed if the complaining witness has not appeared. To the best of my knowledge, she has not today. However, it's my understanding the prosecutor wants to proceed without her by getting her statements in through MCL 768-27C. Thank you.
Thank you, Mr. Sartz. Mr. Pfeiffer, you may call your first witness.
Thank you. And just nuts and bolts. I'm going to, when I get to that testimony, I'll do it the way I always do, which is lay the foundation, then tell the court I intend to proceed under that statute.
Okay.
It'll be pretty apparent when I'm intending to.
And then we can entertain any objection at that time.
Thank you, Your Honor.
For the first witness, people call Officer Peter Howard.
Officer Howard, you can come up here. I'm gonna have you stand right there. Please spell and state your first name and last name for the record.
Peter Howard, PETER HOWARD.
Please raise your right hand, sir. Do you solemnly swear affirm, tell the truth, whole truth, and nothing but the truth under penalty of perjury?
I do.
Right, go and have a seat. As you know, the microphone is for recording purposes, so please project as best you can. And Mr. Pfeiffer, when you're ready.
Thank you. Good morning, Mr. Howard.
Morning.
Where are you currently employed?
The Lansing Police Department,
And what is your role there?
patrol officer, police officer,
How long have you been a police officer?
almost 12 years.
Were you working in that capacity on July 17th, 2025?
Yes, sir.
And on that day, were you initially responding out to 1312 Knollwood?
I was.
Now, is that in Lansing?
It is.
Is that in Ingham County?
Yes.
So, did you end up actually going to that address?
Not the physical address, no.
So why not?
I was looking in the area for the accused that had advised had left that address.
Okay, and why were you doing that? What information had you got?
So we were dispatched to a call about a domestic assault where the accused had possibly broken a female's jaw and was in possession of a firearm.
Okay, and then what information were you given about the person you were looking for?
It was a black male with dreads. I believe there's some additional clothing information dispatched as well.
Were you given a name?
Jabril McGriff.
Now, did you end up finding someone who you believe to be Jabril McGriff?
Yes, sir.
What can you tell us about that?
I was driving in the area. There was a van that he was alleged to have left the residence in that was stopped at King and Willow at a dollar store. It sounds like there was a blue backpack that was in the van that he had left the residence with, but he was not in the van himself. So I began to check the immediate area and I found a male at Princeton and Glen that I believe to be the accused that looked to me that it matched the description.
Now, what did you do once you saw that person?
I followed him for a short distance. I asked a question on the radio about the clothing. It was determined then And I also looked at a photo that had been attached to our dispatch notes of the accused.
And did that seem to match the person that you saw in front of you?
It did.
About ballpark, how far away do you think you were?
When I
at that
first
point?
saw him, probably 25 to 30 yards.
Okay. So what did you do once you got that information that matched up with what you were seeing?
I followed him down Glen Street towards King from Princeton.
Now, when you say followed,
I drove my patrol car,
okay, did you have lights on or were you just still keeping a distance?
just keeping distance at that point, waiting for further description over the radio, just to verify that this was most likely the person we were looking for.
And did you end up getting that further description?
I did.
What did you end up doing at that point?
I approached him in my vehicle at, I believe, King and Maples, and the area made contact with him. I activated my overhead lights on my patrol car, the red and blue flashing lights. I dispatched, or I announced on the radio what I was doing, when I was making contact with the suspect, I believe to be the accused at King and Maple.
And what'd that person do?
I exited my vehicle and he immediately started running in a southwest direction.
And do you give chase?
I did.
Can you describe roughly how that chase went?
I exited my patrol vehicle. As he started running, I announced in a loud voice, police department, stop. He did not stop. And we ran in a southwest direction from King and Maple. We ended up going behind a business that ended up being 1021 North King. We ran through the back parking lot and jumped a small white plastic fence with some brush and some other grasses and stuff around it. We both jumped that fence, continued running southwest through some other backyards. We got to another fence with some brush and stuff around it. He left it effortlessly. I got caught up in the brush and I called out that he was still running southwest after that point.
Now, at some point, are you able to, with the other officers, stop him?
Yes.
How long do you think after he was able to get away from you, do you think he ended up being stopped, roughly?
5 to 8, 10 minutes, somewhere in that range.
Now, once he ended up being stopped, you catch up with him at that point?
Correct.
And were you able to identify him?
Yes.
How were you able to identify him?
He had a Michigan ID in his pocket that was broken into 2 pieces that had his name on it.
And what was that name?
The broken griff.
Now, do you see the person that you were chasing and eventually stopped here today?
I do.
Could you please point out where he's sitting, maybe something that he's wearing that people around him aren't wearing?
Yep, he's a gentleman over here at the left, my left end of the table with the blue jumpsuit.
If the record can reflect that the officers identified the defendant?
Any objection to the witness identifying the defendant for purposes of prelim, Mr. Sarks?
Yes, Your Honor, objection like a foundation. Thank you.
With that understanding, the witness has identified the defendant for purposes of prelim.
Now, once he's eventually stopped, you said that there was an ID found in his pocket. Did you
Yes.
find anything else on him?
Yes.
What did you find?
Some personal items would be the lighter, small amount of marijuana, and there was also a 40 caliber live round in his pocket, a single live round.
Now, did you eventually find a firearm?
We did.
What was that firearm?
It was a Glock 40 caliber.
One that takes the 40 caliber bullet that was found in his
Correct.
pocket?
Correct.
And where was that firearm found?
It was behind 1021 North King, right at the base of that white plastic fence, kind of covered by the grass that we jumped over when we initially started running from my patrol car.
So the exact path of the chase.
Correct.
Now, this chase, was this also in Ingham County? in
Correct.
Lansing?
Yes.
Okay. This is on July 17th, 2025.
Yes.
One moment. I have nothing further, Your Honor.
Cross-examination, Mr. Sarks.
Thank you, Your Honor. Officer Howard, did you ever see the person you claim was Mr. McGriff throw anything when you were chasing?
No.
Did you ever see him drop anything when you were chasing?
No.
And when you first approached the person you claim was Mr. McGriff, well, what was that person wearing?
Jeans and a black sweatshirt.
And the black sweatshirt, was that some type of hoodie or something like that?
Yeah, it was a hoodie. I think it had black writing or some kind of, or sorry, white writing or some kind of white design on the back of it.
Okay. And could you see the person's face when you first approached?
From the back, no, I could not see the person's face.
And was the hoodie up over the person's hair at the time?
I believe it was down.
And approximately, you said you're about 25 or 30 yards behind him, correct?
When I first saw him, yes.
Okay. And during that initial approach, you were running at full speed, correct?
During the initial approach, the first time I saw him, I was in my patrol car, just slowly rolling through neighborhoods.
Slowly rolling. Okay. And you didn't have any lights on, you didn't have any sirens on or anything like that at that time,
At
correct?
that point, no.
All right. And did you even, so from inside the patrol car, did you try to give any commands or any orders or anything along those lines?
No.
Okay. And approximately how long did you follow him in the patrol car?
Probably 30 seconds to a minute.
And then after you followed the patrol car, what happened at that point?
I approached him at King and Maple. I pulled up on the street, kind of on the side of the road. I activated my overhead lights, running the lights in the patrol car. And I opened my door and he began to run away. And I gave the announcement of Kansas City Police Department stop or police department stop.
Okay, but how far was the person you claimed was Mr. McGriff at the point that you actually announced that you were LPD?
Probably 15 to 20 yards. When I got out of my vehicle, I announced in my loud voice, police department stop.
Okay. And this was there a lot of street noise? Were there a lot of other cars around? Were there any other noise? Was there any other noise in the background?
I wouldn't say there was a ton of cars around. No, I wasn't specifically paying attention to the traffic, but it was not an overly loud area.
Okay. And what was the daylight like at that point?
It was daylight. It was cloudy, overcast, but it was 9:45, 10 o'clock in the morning.
And the person you claim was Mr. Griff, that person was running away from you though, correct? And to your knowledge, did that person's hoodie, did it appear to be up over their hair at that point, or was it still down?
I think it was still down.
Okay, but still was a hoodie, so there might have been something that was kind of up near the person's ears, correct?
Could have been, yeah.
All right. And you were making those announcements when you started running, correct?
As I was taking my steps out of the patrol car, as he took off running, yes.
Okay. So the person you were chasing was running there about 15 or 20 yards ahead of you. You were attempting to run at that point. So, but your testimony here though is that your efforts to try to run wouldn't have influenced the volume of your voice or anything along those lines, correct?
I do not believe so, no.
Okay. And then you proceeded to chase this person for how many yards again? Approximately how long?
Well, we started at King and Maple and we ended at King and Oakland, circling through backyards and up and down sidewalks. So whatever that distance would be, a quarter mile, maybe.
Okay. So basically, you lost sight of the person you claimed was Mr. McGriff at some point then, correct?
Multiple times.
Multiple times. Okay. And you did eventually catch up with the person you claim is Mr. McGriff, correct?
Yes.
And he had a hoodie on at that point, correct?
I believe at the end, he did not have a hoodie on because it was called in later that hoodie was in someone's backyard.
Ah, all right. So when you ultimately caught up to the person that you claim was Mr. McGriff, he didn't have that person didn't have a hoodie, correct?
No.
All right. And in terms of the item that was recovered later, this hoodie or whatever that garment was that checked for DNA? Was it tested in any way to verify if that was the correct hoodie?
I don't believe so. It was just returned to him and his property at the jail.
Okay. And in terms of the firearm itself, describe what that firearm was again.
It was a black Glock 40 caliber.
Okay, so it wasn't a 22 caliber?
No.
So if your report reflected that, I'll just read it. A black Glock 22
Objection, Your
handgun.
Honor. Reading from a report into evidence.
Oh, no, I'm just,
Again.
Sounds like it's a cross-examination question.
That's impeachment.
Are the objections overruled?
Thank you. So the report reflected a black 22 handgun. That wasn't accurate.
So a Glock 22 is a 40 caliber. The 22 is the model number, or the model, I believe.
Okay, so it's not a Glock 22 caliber, it's a Glock 22 40 caliber.
Correct.
Okay. And in terms of the particular live ammunition that you described that was seized on Mr. McGriff. To the best of your knowledge, was there any ballistics testing or any other additional testing that was done to that particular item?
Not by me.
Okay, how about with the handgun itself, to your knowledge? Was the gun tested for prints? Was it tested for DNA? Was there any additional ballistics testing done on that firearm?
I am not an expert in that, but to my knowledge, every gun that we seize is ballistic tested. I don't know anything about that. I'm sure this one had the same process go through it to make sure it wasn't involved in other crimes as well. But again, that is not my area.
And to clarify again, where was this firearm found?
Right at the base of a white fence behind 1021 North King, tall grass.
Okay, and how would you describe that area, 1021 North King? Is it an area that the LPD would describe as kind of a high crime area?
Potentially, yeah.
So and the area was heavily overgrown, correct? With a lot of grass.
Probably knee height and height grass, correct?
Okay, so to the best of your knowledge, was there any additional testing done to that firearm afterwards?
Not to my, I don't know, in addition to what our crime techs may or may not have done with the ballistic testing.
Okay, and this was a residential neighborhood, right?
It was residential. The 1021 North King is actually a tire shop, but it is residential area. Yes.
Okay, so there's a tire shop near there, there's a bunch of houses near there. Safe to say there's a decent volume of people who are going in and out of that particular area, correct?
I would not say so in that area the gun was found on sidewalks, correct?
Okay. And in terms of the fence itself, the fence would have obscured anybody from the street being able to see the gun, correct?
Correct.
And the gun was completely hidden, correct? In fact, it took a canine to find the gun, correct?
Correct.
And
Well, actually, we were tracking through the area. The canine walked past the gun and probably 5 feet or so. And I was just moving the grass back and forth with my foot. And that's how we recovered the firearm.
so the canine didn't even find the gun. It was the fact that you observed it when you were just trudging through the area, correct?
We were following the canine through the area and that we ran. And the canine was still looking through the area, and I was just doing my own cursory search of the grass, yes.
Got it. So the canine didn't even indicate on the gun itself, correct?
Not initially, no.
And canines, to your knowledge, are trained to indicate when they find stuff like that, especially if they find the smell, correct?
I'm going to object to speculation at this point. The officer's not a canine officer.
If he knows, but he's not the canine officer. But it sounds like he can answer the question if it's in his expertise. If it's not in his expertise, we'll receive that answer. So the objection is overruled, but you may answer the question if you can.
Can you repeat the question one more time, sir?
Sure, no problem. And just speak from your personal experience. I understand you're not a canine officer, but presumably you've been on a bunch of these canine searches, correct?
Correct.
So to the best of your knowledge, that dog is trained specifically to indicate, locate, scent on certain particular fixed items that might be evidence, such as theoretically potential firearm, correct?
It's not, I'm not trained in it. I'm not an expert in it. However, they do have several different areas that they are usually trained in, and an area search for items is usually one of them.
Okay, but in your observations, the dog went right by the firearm, right?
I wouldn't say right by. We were just searching that general area, probably 5 feet away, circling the general area while I was moving the grass back and forth with my foot.
Okay. And so approximately how long did this whole interaction occur?
From start to finish?
Yeah.
So it was probably about 40 minutes from when I observed Mr. McGriff to when we found the firearm, approximately.
Okay, and approximately what time of day did this get started again?
About 9:45, 9:47, somewhere in there.
9:47. Okay. Nothing further, Your Honor. Thank you.
Thank you. Redirect Mr. Pfeiffer.
Now, you were asked about there being a lot of people around this area, and you said, well, on the sidewalks, it was residential. Did it appear to be that there was a lot of foot traffic on this actual spot in the tall grass by this fence where the gun was found?
No.
Did it appear that the gun had been there for a long period of time?
No.
What makes you believe that?
There'd been a light rain that morning. The gun was not covered in dirt. It was not covered in rust. It wasn't wet. It was just sitting under the grass in a pretty clean state.
Okay. So to you, that indicates that the gun had been there, put there recently.
Yes.
Now, there's also questions about what you wrote in your report about the gun. with the claim that it was actually a 22. I'd like to approach you with a copy of your report. Now, I've circled the part that was questioned about. Could you please read the whole line and not just the first couple words there?
Yep, so evidence item 3, black Glock 22 handgun, 40 caliber, serial number DFW 406 US, registered to CMP distributors.
Okay, so you actually wrote in your report that it was a 40 caliber.
Yes.
And if you had read even a couple of words past what was read to you before, it would say the words 40 caliber.
Yes.
Nothing further.
May this witness be excused from the people,
You may, Your Honor.
from the defense, Mr. Sarts.
Yes, Your Honor, thank you.
Thank you for your testimony today. You're excused. And the people may call their next witness.
Thank you. The people will call Officer Tyler Stover.
Officer Stover, you can come forward. You stand right in front of me and please spell and state your first name and last name for the record.
Tyler Stover, Tyler Stover.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I swear.
Right, thank you. As you know, the recording is just for the court recorder, so please amplify your voice as best you can. And Mr. Pfeiffer, you may proceed.
Thank you. Good morning, Mr. Stover.
Morning.
Where are you currently employed?
City of Lansing Police Department.
And what is your role there?
I'm a patrol officer.
Now, Officer Stover, how long have you been a police officer?
3.5 years now.
Were you working in that capacity on July 17th, 2025?
I was.
On that day, were you dispatched out to 1315 Knollwood? Is
That's correct.
that in Lansing?
It is.
And is that in Ingham County?
It is.
Now, on that day, did you make contact with a Lene Corley White?
I did.
And as a result of speaking with her, did you determine that an assault had taken place?
Yes, I determined that domestic assault had occurred.
And did you determine that it had taken place recently in time?
Yes, within the last hour when I had spoken to her.
And what was her demeanor like when you were talking with her?
As far as I remember, she was crying. She looked visibly upset.
Your Honor, at this time, people are going to seek to move forward under MCL 768.27C. I believe there's been sufficient foundational basis under the statute.
Thank you. Objection, Mr. Sarts.
Thank you, Your Honor. Yes, the defense would object to the prosecutor being permitted to move pursuant to that statute at this time. Respectfully, the defense would object on grounds of a lack of foundation here, lack of indications of potential reliability, the possibility of witness bias, including a possible custody dispute because they have a child in common, and other considerations, Your Honor. So respectfully, the people have not met the foundational requirements for the statements to come in at this time, and the defense would state objections continuing moving forward for the statements coming in pursuant to that statute. Thank you.
Thank you. Response, Mr. Pfeiffer.
Yeah, if Mr. Sarks wants to put a witness up to testify of possible bias, he can. He can't testify to that himself. I believe there has been sufficient factual basis here, not only with this officer, but with the testimony of the prior officer to help with element D, that being the corroborating circumstances.
Pursuant to 768.27C, which was promulgated by the legislature in this matter, for preliminary examination only, since we're not at jury trial, evidence of a statement by a declarant relating to infliction or threat of physical injury is admissible if all the following apply. The statement purports to narrate, describe, or explain the infliction or threat of physical injury upon the declarant, the action in which the evidence is offered in an offense involving domestic violence. The statement was made at or near the infliction or threats of physical injury. Evidence of statement made more than 5 years before the filing of the current action or proceeding is inadmissible. This was within the hour. And the statement was made to a law enforcement officer, as Officer Stover has testified. Trustworthiness, concerning trustworthiness may be perceived in this matter, whether the statement was made in contemplation or pending anticipated litigation in which the declarant was interested. There's been some indication of that. Whether the declarant has a bias or motive for fabricating the statement and the extent of bias or motive, there's been some indication made of that. And the statement is corroborated by evidence other than statements that are admissible only under 768.27C. There is other confirming evidence involving the previous testimony of the officer. I find that domestic violence statements are acceptable and confirmed and admissible pursuant to 768.27C for purposes of this prelim only. So the objection is overruled, and Mr. Pfeiffer, you may proceed.
Okay. I thought I heard you say that they were inadmissible. It's the rulings that they're admissible.
They're
correct?
admissible.
Okay, perfect. So, Officer Stover, what did Miss Corley White tell you had happened to her that day?
Miss Corley White told me that Jabriel McGriff had come over. Jabriel is the father of their, I believe, 1-year-old child. She said that he had a key to her house, but they never lived together. And that they began to argue over a female that Mr. McGriff had brought over to her house, to Miss Corley White's house. She said during the course of that argument, Mr. McGriff slapped her in the face one time, and she had fallen to the ground.
You're saying Mr. McGriff, right?
Correct.
I heard Miss McGriff. That's
Mr. McGriff, let me
Okay.
clarify, Jabriel McGriff.
perfect. He had slapped her one time. She fell to the ground. What'd she tell you about how he got into that residence that day?
She stated he had a key to the house. I don't recall as to how he actually entered the house. I would assume it was.
But did she say if she had given him permission to enter there?
I don't recall.
Looking at a copy report, refresh your recollection to that point.
It may.
If I may approach, Your Honor, it's a clean copy and it's, I'm gonna have it turn to page 10.
Thank you.
Now, Officer Stover, I'd like you to read this to yourself silently until you feel it's sufficiently refreshed your memory as to this point, or you feel it's just not gonna be possible to do so. When you're done, let me know, take it back from you, ask you the question again. All set? Now, Officer Stover, did that help refresh your memory to that point?
It did.
So, do you remember her telling you anything about how he entered or whether he had permission to enter?
I do not. I do remember her telling me that he had a bond conditional release, saying he was not allowed to be at the house, but
And she never told you that she had given him permission to come there?
no.
Thank you. What did she tell you happened after he hit her in the face?
Mrs. Corley White stated that she was slapped again by Mr. McGriff. She stated that they then went outside somehow, circumstances that are unclear. At that point, they continued arguing and fighting outside. She stated that Mr. McGriff grabbed her jacket and cell phone and threw them to the ground. And she stated she believed that was due to Mr. McGriff not wanting to call her to call 911.
So her phone damaged as a result of that?
Correct. And I believe about that time, we received the first call where we responded out there. Myself and other officers attempted to make contact at 1315 Knollwood.
Was that successful the first time?
It was not. No, we received no answer at the door. I didn't hear anything from inside the house. I spoke with the original reporting party who couldn't provide any further information. I attempted to call Mrs. Corley White based on a phone number that we had previously for her. I received no answer.
So now that you're able to actually talk with Miss Corley White, did she tell you what happened the first time you guys came out?
Yes, Ms. Corley White stated that shortly after her phone and jacket were thrown on the ground, Mr. McGriff stated he was going to go inside and break things inside of her home. She stated she followed him inside. And then shortly after, officers arrived at their house, or at Ms. Corley White's house at 1315 Knollwood. Ms. Corley White stated that she heard officers knocking outside, and she stated that Mr. McGriff produced a black handgun and pointed it at her, told her not to answer the door, and that he would shoot her if she answered the door or spoke with police.
So the first time you guys went out there, when you're on the one side of the door, knocking to talk with her, she's telling me on the other side, Mr. McGriff was pointing a gun at her.
Correct.
Did she say where he pulled that gun out from, your memory?
No, I don't believe she did.
Do you remember her talking about having the gun basically on his person at some point?
Yes.
And what do you remember her saying about that?
She stated he put it into his jacket pocket.
Now, what'd she tell you happened after you guys left the first time?
I don't recall what she said exactly had transpired.
But at some point, what'd she tell you about him leaving?
She stated she had called for a ride for him, and that her friend or his friend had come and picked him up in a silver Dodge minivan.
So after he left, that's when you were respond out the second time, were able to get this information.
Correct.
And did you put this information into, dispatch letting other officers know?
Correct.
Now, do you remember if she had any injuries on her when you were talking with her?
I remember specifically she had what appeared to be a bruise on her arm. I don't recall which arm, but it looked from my training experience as if it were a bite mark. And she did state that she was bitten by Mr. McGriff. She couldn't recall when in the assault she was bitten by him.
But she was too sure it happened during this, not anything prior.
Correct.
Okay. And did she tell you after he left where the gun was?
She stated she thought he had it on him still. She said that she didn't think it was inside the home anymore.
And the gun wasn't found inside the home, correct?
Correct.
Okay. Your Honor, at this time, people have no further questions for this witness.
Cross-examination, Mr. Sarts.
Thank you, Your Honor. So Officer Stover, did Ms. Corley White ever describe to you what specific type of gun this was, other than just using a term of a very generic term?
She described it as a black handgun. I believe she called it large
Okay,
at one point.
so she never referred to it as like a 40 caliber or any sort of technical term for the model or make of the gun, correct?
That's correct.
And she never mentioned anything about Mr. McGriff having gloves on while this was allegedly going on, the entire fight or interaction, correct?
As I recall it, no.
Correct. So she never mentioned anything about someone she was claiming Mr. McGriff wiping the gun down afterwards or trying to cover his hands in any way, correct?
I don't recall her making any statements.
All right, and she never made any indications about him ditching a gun or anything like that, correct?
No, the only statements regarding the gun is that he had pointed at her and that he had put it in his coat pocket.
In his coat pocket. So did she ever describe what that coat looked like?
She did not.
Did she ever describe what clothing Mr. McGriff was wearing at the time?
She did.
Okay, and what was her description of clothing?
A gray sweatshirt and jeans.
A gray sweatshirt and jeans. Okay. And did she describe whether that gray sweatshirt was also hoodie?
No, she did not.
Okay, so just a gray sweatshirt and jeans. And did she describe what alleged time she tried to call him?
She did not.
And did you go out later and talk to a neighbor? Or was that another one of your officers?
I believe that was another officer. I don't recall talking to a neighbor.
Okay. Were you aware that a neighbor claimed that they were recording?
Objection, Your Honor. He is asking for information given to a completely different officer, and he's trying to introduce hearsay.
Response.
Your Honor, I'm just asking if he was aware of a neighbor in the area.
He can indicate if he was aware of what he was aware of, but he can't get in the substance of the conversation. with that understanding, the objection is clarified and it has been overruled. And then you can indicate if you were aware.
I guess I spoke to a neighbor over the phone during the first call for service. I did not speak with the neighbor after I'd spoken to Ms. Corley White.
Okay. And do you recall what approximate time you talked to that neighbor during the first call of service?
I do not recall, no.
But that was also on the same date, correct?
Yes,
Okay. And so were you part of the first team that responded initially?
I was.
Okay, and what approximate time was that?
I don't recall exactly what time that was.
Okay. And then you later went back to the location around 9 o'clock, and that's when you talked to Ms. White, correct?
Correct, around 9:47 hours. I was dispatched the second time at 13:15 Wood.
Okay. So it was Ms. Corley White then who claimed the altercation occurred around 9 o'clock?
Correct.
Okay. And so when did you first respond then?
I don't recall. It was sometime before 9:47.
And then you later went back after around 9:47 or so, and that's when you had the conversation with Ms. White, correct?
Correct.
Okay. And Ms. White wasn't taken to a hospital or anything like that, correct?
Correct. She refused medical transport.
And to the best of your knowledge, she's never contacted you later or afterwards and claimed there's any sort of injuries or anything like that, correct?
She's never contacted me.
Yeah, she ever contacted
No.
you afterwards and claimed there's some type of injury or anything along those lines? No? Okay. And did you take pictures of her at the time when you were having this conversation with her?
I did.
All right. And are you aware of any mental health issues or medicines or intoxicants that might have impacted her memory?
Impacted Miss Corley White's memory?
Yeah.
No, I'm not aware of any of that.
Did you even ask her or did you even check to see if she might have been intoxicated at that time or impaired in any way?
I did not, but that's not typical with domestic assault.
That's not typical or is typical?
It's not typical. No, officers don't typically check victims of domestic assault to see if they're intoxicated.
All right. Did she smell anything to you? Marijuana, alcohol, anything?
I don't recall smoking.
All right. And did she advise of any possible mental health issues that might impact her memory at the time?
She did not.
Okay. And in terms of her physical appearance, did you observe any very obvious injuries?
Other than the bruise on her arm, no.
So nothing in terms of her face?
No.
Even though, but her claim was that Mr. McGriff had broken her jaw or something to that effect, correct?
I don't believe she said he broke her jaw. She said that her jaw hurt.
Okay, but you didn't observe any obvious injuries to her jaw, correct? How about redness to her face? How about any indications of like a palm print or hand print or any sort of indications on her face at all?
I don't recall seeing any injuries on her face.
Okay. And was there anybody else in the room at the time that you're talking to her?
No, there was not.
Okay. Was there a dog in the house or anybody else in the house at the time?
I believe there was a dog.
Okay. And approximately how long did you have this conversation with Ms. White, to the best of your recollection?
I don't recall the exact amount of time that I spoke with Miss Corley White.
Okay. And it's also true, though, that she mentioned that she threatened us to stab Mr. McGriff. Isn't that true?
Correct.
Okay. And my apologies, Your Honor. You said one more. Nothing further, Your Honor. Thank you.
Redirect Mr. Pfeiffer.
No. No, the people are satisfied.
May this witness be excused from the people.
You may, Your Honor.
Mr. Sards.
Yes, Your Honor. Thank you.
Thank you for your attendance today. Your excuse, sir. Any further proofs today, Mr. Pfeiffer?
No, Your Honor.
Do the people rest?
They do.
Any proofs today from the defense, Mr. Sarks?
No, Your Honor, thank you.
Motion for bind over, Mr. Pfeiffer.
Yes, Your Honor. I'm just going to take these in order. There is going to be a couple that I'm taking out and a couple that I'm adding in. So I'll try and make it very abundant. Sorry, Wendy. Count 1, interfering with a crime report by committing a crime or threatening to kill or injure. It's pretty clear from the testimony here, he threatened to kill or injure her. When the cops are knocking on the door, he's telling her don't answer and has a gun pointed at her, threatening to shoot her. So pretty sure that the elements are there for that one. Then count 2, weapons carrying concealed. He had the gun in his jacket pocket, jacket, sweatshirt, hoodie, whatever you want to call it, article of clothing he was wearing, that is enclosed. And that is carrying a concealed gun on him. Now, count 3 is the one that people are going to request just be dismissed because we don't have the evidence here for the prior history. Count 4, house or home invasion, 3rd degree. I'm going to request that be dismissed. I'm going to be requesting it as a home first at the end of all of this. Count 5, felonious assault. He pointed a gun at her. He threatened to use it on her. We know from the first officer's testimony the gun was loaded and it would cause a reasonable person to fear injury. So I believe that all the elements are there for that. Count 6, police officer assaulting, resisting, obstructing. The officer told him, police, stop. He didn't. In fact, he then decided to break out into a sprint, jump multiple fences to get away from him. And while the defense kept questioning about, well, how far away were you? Was there other noise that could have made him not hear you? I highly doubt, especially for a probable cause burden, that the defendant decided that was a perfect time to get in some cardio and start running through brush and jumping over fences, right? The exact moment that a police officer hit the lights, got out of the car, and was shouting, stop. JBO McGriff, stop. So I believe there's sufficient factual basis for count 6. Count 7, felony firearm for the interfering with a crime report. I think that one's pretty self-explanatory. Count 8, weapons felony firearm. I'm going to request that instead of the underlying felony, if that being home 3rd, to instead be a home 1st, which I'll talk about in a second. And then count 9, felony firearm for assault with a dangerous weapon. Again, it's pretty self-explanatory. Dangerous weapon was a firearm. Count 10's misdemeanor domestic violence, which we just carry over. So I'm requesting an added count 11 of home invasion in the 1st degree. The PAC code for that being 750.110A2. As the defendant at 1312 Knollwood Avenue entered an apartment he did not have permission to be at. And while entering, president, or exiting, did commit an assault. Committed multiple assaults. And or committed a felony, that being felonious assault and interfering with a crime report by threatening to kill or injure. And then 3rd, while entering, president, or exiting the dwelling, he was armed with a firearm, dangerous weapon, and or the victim, Lene Corley White, was lawfully present therein. The facts of this case meet the elements of this charge in about 6 or 7 different ways, any one of which is enough for bind over. With that being said, Your Honor, I'm requesting bind over on those charges.
A response to motion for bind over, Mr. Sarks.
Thank you, Your Honor. Respectfully, the defense would object to the request for bind over here on all these counts and request dismissal of the charges at this time. Respectfully, there is ongoing concerns about the trustworthiness of the statements that were produced through MCL 76827C that allegedly came from Ms. Corley White. There are some notable inconsistencies in terms of her testimony. There are certainly reasons to doubt the trustworthiness of her statements. Of course, she's not here, Your Honor, so the people are relying on her statements pursuant to that statute while they're requesting bind over, and the court can consider credibility or lack thereof when evaluating the decision to bind charges over. And I will certainly note, Your Honor, of course, that the credibility thresholds are very low for the purposes of a preliminary examination, but still, credibility is something that the court should consider when deciding whether to bind the charges over. Regarding interfering with a crime report, respectfully, the hearsay statements through Ms. Corley White don't seem to really add up or make much sense. There's too many doubts about the credibility of her alleged statements to bind over that particular count. And in terms of count 2, when none of the officers claimed that they saw Mr. McGriff carrying any sort of concealed weapon. They claim that they found a gun later, but by accounts based on their own testimony, there is no circumstantial evidence other than the approximate location as related to Mr. McGriff that would connect Mr. McGriff to that particular count, other than they do claim that they found a slug, some ammunition, but there's no ballistics that's going to connect that particular round of ammunition to that particular gun. There's been no testimony about how that gun is connected directly to Mr. McGriff, whether it's through DNA, whether it's through fingerprints, or through anything else. Mr. McGriff was certainly a considerable distance away, even from when he was ultimately arrested. And from the location of this firearm, this is a mixed residential and business area. The grass was heavily overgrown. And while the officer describes a situation where, in his view, the gun might have been a little more fresh, that doesn't mean the gun hadn't been dumped there, several hours prior or several days prior. The grass was heavily overgrown. Obviously, it would have been very hard to see. It was a very concealed area, and plenty of people had access to that location. It's a very weak, very circumstantial allegation of constructive possession to even attempt to connect Mr. McGriff with that alleged firearm. And if Officer Howard is to be believed, in terms of his testimony here, even he claims he never saw Mr. McGriff ditch a gun, carry a gun, drop a gun, anything like that. And Officer Howard alleges that he had eyes on him for extended periods of time, albeit he also admits that he lost track of him several times. But now the canine, Your Honor, walked right by it. So if Mr. McGriff's had been allegedly handling that gun at that time, you'd figure a dog with incredibly sensitive noses, the same dog that had been able to track who they claim was Mr. McGriff the entire time, would have found the gun. Mr. McGriff's scent should have been all over that alleged firearm if it was connected to him. There was nothing from Miss Corley White that suggested that Mr. McGriff at the time that he was allegedly handling a firearm had been wearing gloves or had been trying to cover up his scent or anything like that. On the contrary, Mr. McGriff's scent should have been all over that alleged firearm if that was in fact something he allegedly handled. Again, I understand these are questions of fact, but still they go to the credibility of the proofs here, Your Honor. And this is a very, very weak allegation by the people as it relates to all these firearm counts, attempting to connect Mr. McGriff to those counts. And then it all gets back, of course, to Miss Crowley White, who's not even here. And then people were, of course, relying on her hearsay statements pursuant to MCL 76827C. And that carries into Officer Howard's testimony regarding resisting obstructing charge. Respectfully, the people haven't met their burden there as well. There's too many questions about the credibility of Officer Howard's statements, but the bigger issue is there's too many questions about the intentions of Mr. McGriff here. There's an element of intent that goes into those allegations based on the distance and based on the timing and alleged circumstances here. It's a very open question about that particular element, and respectfully, the people haven't met their burden. So I would carry over my objections as relates to the felony firearm counts in terms of the claims for home invasion. Permission to enter, that's a legitimate question. It's not very clear based on the testimony. Respectfully, there's been no introduction of the paperwork that would support the people's claims that there was a order or some type of, and it's quite possible, but the people have not produced for Your Honor a certified copy of a court order or PPO or anything along those lines that would support their allegations regarding the existence of orders along those lines. It's, that's their burden. It seems obvious. It was in the court's jurisdiction possibly, but still, that's their burden to show the existence of such an order. And there are doubts about whether Mr. McGriff had permission to be in there or not, based on the conflicting and somewhat confusing recollections of the officer and some of the own statements, contradictory statements from Ms. White about that issue. So respectfully, Your Honor, the people have not met the burden for their request for the added home invasion count either. So all in all, Your Honor, I respectfully defense requests that all these counts would be dismissed at this time. Thank you.
Response to motion for bind over.
Yeah,
Mr. Pfeiffer.
there's a lot, but I'm gonna try and do this as concise and quick to the point as I can. That's not how the dogs work when they look for firearms. That's not how that works, which is why for testimony like that, we'd have an expert, which Mr. Sartz is not. Secondly, the officer testified that the gun was found in the exact spot where the defendant hopped the fence and testified that the gun was not there long because it did not have any dirt or even water on it from the rain earlier that morning. Again, what Mr. Sartz is saying is not what the testimony was at all, and also conveniently leaves out the fact that a .40 caliber slug that fits that gun was found in his pocket. And then he also said that there was no ballistics run to prove the gun was with that bullet. That's also not how ballistics work. You can only get ballistics off of that once it's been fired out of a gun, which wouldn't be the case with a live slug. That's not a thing. But again, that's why attorneys don't testify. Witnesses do. The evidence here is sufficient for bind over. I'd ask you bind it over as requested.
Thank you. So the standard for preliminary examination is probable cause being the second lowest standard in criminal law, reasonable suspicion being a lower standard. I find that this all happened in the city of Lansing. So the venue and location that started, the initial assault starts at 1315, alleged assault starts at 1315 Knollwood Apartment 2, City of Lansing, Michigan, on July 17, 2025. That is location, venue, and date. Identification was made by Officer Peter Howard, along with Officer Tyler Stover testified. Officer Howard indicated that the identification of Jabril McGriff as being the person who was involved in the initial assault, and as at least indicated, identified him in the courtroom and indicated that that he was doing a follow-up as to the initial report. It was at that time that he told Mr. McGriff to stop. There's some question that of how far he was, as 15, 20 to 30 yards. But I think that count 6 has been met at a probable cause level that the defendant did resist and obstruct the Officer Peter Howard on July 17th in the city of Lansing, and as indicated, did obstruct or oppose Officer Howard, a police officer of the Lansing Police Department. The defendant knew or had reason to know was performing his or her duties. I believe count 6 has been met at a probable cause level. There's also an indication that in count 2 that there was a gun involved, that the gun was initially from another testimony from Officer Tyler Stover, using the statements of pursuant to 768.27C of Miss Corley White, indicating that the gun was placed in his jacket. He was then reported to be part of the resisting and obstructing, which ended up being a gun was found in the route of the resisting and obstructing, which indicated that when he was initially searched, incident to arrest for the running purposes, there was an ID found, that was identification was found, and then the ammunition, .40 caliber ammunition was found, and then the search for the gun on the route was found on the Glock 22 was found. There's some testimony concerning whether the dog missed the gun and then the officer was able to find the gun. I wasn't there, but I do think the testimony of the officer is that the dog was 5 to 6 feet away, and at that time the officer was along very large grass. I think the grass was described to be three feet tall, was moving the grass so you could see the bottom, and that's when the gun was found. I believe probable cause evidence to bind over on count 2 is met. The defendant did carry a dangerous weapon, to wit a Glock 22 handgun concealed on his person or about his person. And count 2 is met at a probable cause level. So that's count 2. Count 1 would be to Tyler Stover as the indication during his testimony that while being there present during the crime, the first report, the victim indicated that the defendant had a gun on his person, threatening to use a gun if any contact with law enforcement was made. That would be as to count 1, that the defendant did on July 17, 2025 at 1315 Knollwood, apartment 2 in the city of Lansing, did through the unlawful use of physical force prevent or attempt to prevent another person from reporting a crime. This is the pointing of the gun at Miss Corley White, and violated involved threatening to kill or injure any person, certainly threaten to injure the person, contrary to law of the state of Michigan. Count 1 is found to be bound over at a probable cause level. The people are moving to dismiss count 3 and count 4. Count 5 is the felonious assault with a dangerous weapon. And I believe that that's been made at a probable cause level that indicated that he pointed a gun at her on July 17, 1315 Knollwood in the city of Lansing, that he used a Glock 22 handgun that later was found. And that's a Glock 22, it's a 40 caliber handgun, but without intending to commit the crime of murder. Count 5 is bound over at a probable cause level. Count 6 is the initial bind over of the resisting and obstructing. Count 7 would go to the interfering, so it's felony firearm, using a felony in the commission of a felony, and that one's related to the felony, to the interference. So count 7 is bound over. Count 8 would lead to the home invasion 3rd charge that has been adopted to the home invasion of 1st charge. So count 8 has been bound over on a probable cause level. And count 9 is assault, felonious assault, that is bound over at a probable cause level, in that the defendant did carry or have in his possession a firearm, to wit Glock 22 model handgun, 40 caliber, at the time he committed the felony of a felonious assault dangerous weapon. Count 10 is the misdemeanor, which follows. And then count 11 is the reintroduced home invasion 3rd count from count 4 that was previously dismissed, in that there's some question concerning whether there's a question that he had a key to the house or apartment. There's also, it's unquestionable that the defendant was not given permission to go into the house by Miss White sometime after the fray. And so when she said, "You're not supposed to be here," whether she believed there was a valid order or not, she's indicating that he cannot come in. That would suffice for our purposes of a prohibited entrance as to the home invasion entrance for both a 3rd and a 1st, but now it's been requested for a 1st in count 11, that when he was entering, exiting, or present in, exiting, or dwelling, that he committed a felony or an assault upon Miss Corlin White is the testimony, and that she was present in the address, and the defendant had a dangerous weapon is the theory. He pulled a dangerous weapon when he indicated that he did not want her to talk to the police, and that she indicated that it was pointed at her. I believe the home invasion 1st has been proven at a probable cause level for count 11 purposes. That's a 20-year, I believe.
It is, Your Honor.
So counts, in order to reiterate the bind over, counts 1, 2, 5, 6, 7, 8, 9, 10 goes along as a misdemeanor, and count 11 are bound over to circuit court, and the people move to dismiss counts 3 and 4. This is based on the testimony of the two officers and the use of the victim's statements pursuant to 768.27C. So your time in district court is done, Mr. McGriff,
On this file.
on this file. On this file, your time on 2502-186, your time in district court is done. You're off to circuit court. Well, you'll get your next, you get your next appearance in circuit court when to appear from your attorney, Mr. Sartz. I'm binding over, and this is really for the ROA, request of action. I'm going to bind over on counts 1, 2, counts 1, 2, 3, and 4 dismissed. 5 through 9 are bound over as charged. Count 10 follows as a misdemeanor, and count 11, this case is bound over on home invasion first, is bound over on count 11. So you'll get your next appearance will be in circuit court. The examination was held on today's date, which is 8/28/2025, and the charges are amended pursuant to what I've indicated on the record. Anything else for the record on docket 2502-186, Mr. Pfeiffer?
Not on behalf of the people, Your Honor.
Mr. Sartz.
Thank you, Your Honor. On behalf of Mr. McGriff, I request a reduction in his current cash surety bond. Right now, Your Honor, respectfully, his bond is set at $100,000 cash surety. Mr. McGriff is only 22, Your Honor. This amount is way beyond anything that realistically he could ever financially hope to post or afford, and it's way beyond the means of his family as well. Your Honor, respectfully, I would request a reduction in this cash surety amount. Mr. McGriff is not a flight risk. He has plenty of connections to the local community. He has a lot of family support. In fact, members of his family are in the gallery here. He would make sure that he maintains a stable address. He'd like an opportunity to get out and work. He would have a stable place to stay with his mother. Your Honor, he would comply with all the court's orders and make sure that he reports to pretrial services. He's agreeable to even a tether, and concerns about safety for Mr. Crowley White, can be addressed through the use of tether monitoring and a curfew. He has significant financial obligations that he would like to work towards paying those down if he is released. He is, of course, presumed innocent, Your Honor. This could be quite a long process here. And with that $100,000 cash surety amount, there's no way that he would be able to ever realistically post that. Now, while the charges here are serious, Your Honor, Mr. McGriff does have his rights during this process. He still is, of course, presumed innocent. And respectfully, I request a reduction on his behalf this time. Thank you.
Thank you. Response, Mr. Pfeiffer.
Sure. Let's see, 2019 firearms charge, 2019 home invasion charge, breaking and entering charge, 2023 firearms charge, 2023 firearms charge, 2024 assault resisting obstructive officers, 2024 tampering with an electronic monitoring device, 2025 we have all of these charges. Then look back 2022, attempting to take a cop's gun, firearms charge, resisting obstructing officer, resisting obstructing officers, firearms charge. I think bond's appropriate where it is.
All right, I'm going to deny the motion to reduce bond, and you're off to circuit court. Will you get your next appearance from your attorney, Mr. Sartz? Anything else for the record in docket 2502-186, Mr. Pfeiffer?
Not on behalf of the people, Your Honor.
Mr. Sartz.
Not at this time, Your Honor. I'll just request the transcript, so thank you.
All right, thank you. We will have the transfers to be signed for, and I will sign the bind over documentation. That's all for the record in 2502-186.
Thank you, Your Honor.
Thank you.
Yeah, no, that's, be sure I have my meeting this afternoon.
I did that, so you didn't have to try to smally write on the mind over.
We'll add it just in case, so they can't, when they say they can't read my writing.
Mr. Jones, you want to sign the form, it's right here. I get to go off the give it to you.
I'll take it.
Uh,
I'm gonna put that right. I'll put it on top.
Yeah, there's an end date.
I wrote the same, but it kind of, you know, sneak.
Yeah. I like to do the.
Thank you.
Okay.
So, Mr. Starks and Mr. Pfeiffer, I will see you both tomorrow.
Yep.
All right.
Here you go.
Thank you.
No problem.
Me
And
too.
this is
Yeah.
Mrs.
All
Narrows.
of us.
He also.
Oh, we'll see him. I thought you were on this. I'm sorry.
I don't think yeah, I don't think I have anything criminal this afternoon.
Yeah.
I think those are all Mr. Smith cases.
This feels like maybe an apple punch problem.
It's not a problem. It's actually a thing. Sort of.
Have a nice day.
You too.
Hello.
Hello.
All right, sir, on the Samsung cell phone, could you please identify yourself? You'll have to unmute. You'll have to unmute.
Aaron Collins.
Aaron Collins, all right. I'm going to rename you, and you're in the right place, Mr. Collins. We'll call your case in just a second.
Yes, sir.
Oh, you already did it. All right. All right, Mr. Burnett, we're ready to call your first case with Miss Purdue. So we're on the record in 00020066. That is Lafque versus Lamina Purdue. Appearances for the record, Mr. Burnett.
Yes, good afternoon, Your Honor. My name is Joe Burnett. I'm actually filling in for Tim Smith on behalf of Lafque.
All right, and ma'am, you are Lamia Purdue, is that correct?
Yes.
Thank you. This is time set for a motion to show cause. Mr. Burnett, how did you want to proceed?
Your Honor, I believe that we were.
I think did this come out of it? Just fail to appear for discovery matter, and we set it for show cause.
I believe so, Your Honor. I think it might be beneficial to go in a breakout room with Miss Purdue, if that's okay.
All right. Would you be looking, should we continue the discovery hearing? I can swear in, and then we can have any discovery hearing I can place in a breakout room. Did you want to proceed in that fashion?
Yes, Your Honor.
All right, Ms. Purdue, what I'm going to do is I'm going to swear you in. I'm going to move you over to a breakout room with Mr. Burnett so you can finish off the discovery hearing, and there won't be a bench warrant issued for your fail to appear at the discovery hearing. All right, ma'am?
Your Honor, can I say something real quick, please?
You can.
The failure to appear the first quarter date, they gave me the wrong judge. So I was in the Zoom meeting. They gave me Judge Cynthia Ward. That's what showed up on
there's no fail to appear for today.
Okay, but the first one that I was supposed to go to, I was in the Zoom meeting.
All right. All right. So there will not be a show cause issued since you're here, and there was some Zoom mistake. But we will finish the discovery hearing, or at least you can start it, and then we won't have any issue, and we'll go from there. We'll come back and put it on the record, anything that you do. But let me swear you in, ma'am. So raise your right hand. Do you solemnly swear from tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, I do.
All right, Mr. Burnett, I'm going to put you in room 1 along with Ms. Purdue, and then we can come back and place it on the record.
Okay, thank you, Your Honor.
All right, so you'll get a prompt to go to room 1, and Ms. Purdue, you'll also get a prompt to go to room 1. Perfect. All right, Mr. Collins, we'll call your case as soon as Mr. Burnett becomes available. All right, sir?
Yes, sir.
All right. All right, Mr. Burnett, we're going to bring back Ms. Purdue, and then we'll go on the record. All right, so we're on the record in docket 002066. And Mr. Burnett, did you have the opportunity to speak with Ms. Purdue in a breakout room?
Yes, Your Honor, we had a good discussion. Miss Purdue, she did inform me that her last name now is Walker. So Miss Walker and I had a good discussion. She agreed to a payment plan, Your Honor. She's willing to pay $30 a month, beginning September 15th. I gave her our address and everything. And then also I said that she could send the documents we're looking for out of the subpoena. She can send those to the same address. At this point, Your Honor, I would just like to request a control date, perhaps in late September, just to give her some time to send those documents to us.
All right. And Ms. Purdue, is that an accurate statement of what happened at the discovery proceeding?
Yes, Your Honor.
All right, so let's set it for a control date at the end of September, or very beginning of October, whatever fits. Whatever fits.
Even here. Oh, that's a definite wrong button. October 21st at 3.
It's the soonest date, October 21st.
For civil discovery, yes.
All right, we'll set it for control date, October 21st at 3. And then, Mr. Burnett, you can let us know if we need that date. That'll be an outside date, just to make sure all of the discovery is met on the matter. So October 21st at 3 o'clock. Anything else for the record in docket 002066? Mr. Burnett.
Nothing else, Your Honor. Thank you.
Ms. Purdue, do you have any questions of me?
No, thank you, Your Honor. Thank you.
All right, you should be all set, ma'am. Thank you for your appearance today.
Okay, thank you.
All right, and then we have, let's call Mr. Collins, because he's been waiting, and then we'll do the no-shows. I think Ms. Trudeau is a no-show, but we'll do that after you can meet with Mr. Collins. So let's see. That's Aaron Collins. Trudeau. Oh, that's a regular file. All right, so we're on the record in docket 16022321. That is Lafque versus Aaron Collins. Appearances for the record, Mr. Burnett.
Yes, good afternoon, Your Honor. My name is Joe Burnett. I'm filling in for Tim Smith on behalf of Lafque.
And sir, you are Aaron Collins, is that correct?
Yes, sir.
Okay. This is the time, and you can hear me all right, Mr. Collins?
Very clear.
All right, thank you. I'm going to indicate that all parties appeared. This was the time set for a discovery hearing. Mr. Burnett, would you like me to swear in Mr. Collins? We can put you both in a breakout room so you can have some private discussions.
Yes, Your Honor. Thank you.
All right, Mr. Collins, I'm going to swear you in, and then I'll put you in a room via Zoom with Mr. Burnett, and you can go through the discovery materials that are necessary for that discovery hearing. All right, sir?
Yes, that sounds good.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
All right. I'm going to indicate that all parties appeared. Mr. Burnett, you can go back to room 1, and I'll put Mr. Collins in room 1.
Okay. Thank you, Judge.
Thank you. Mr. Bears, do you expect Mr. Smith on this? I don't know if Mr. Smith is gonna be here.
I do not know.
All right. Let's, we'll give him some time we'll give him a few minutes. This is really just as to go over, I'll tell you, the civil department indicated that they believe that the order had cost too high and too allocated. We'll call it and put it on the record. But that's the nature of why the hearing was set.
Okay, thank you.
All right, you're welcome. All right, on Dan's S24 Plus, could you please identify yourself? I just let you into the Zoom courtroom. You'll have to unmute. Are you Dan Smith, sir?
All right, can you hear me now?
Sir, I can. Are you Daniel
Okay.
Smith?
Yes, sir.
All right, thank you. So I'm going to go ahead and call that case. We can call 2502. Bring it up here. 2502-764. That is Capital One NA versus Daniel Smith. Appearances for the record, Mr. Bears.
Good afternoon, Your Honor. Jeffrey Beers, P 41693 on behalf of plaintiff Capital One.
All right, and sir, you are Daniel Smith, is that correct?
Yes, sir.
And you can hear me all right, Mr. Smith?
Yes, I can.
All right, thank you. This is the time set for it's really set for a hearing entering judgment. Mr. Bears, this happens, I say once or twice, once every 6 months or so, so twice a year. The civil department contacts me, and in regards to the expenses, they want it itemized. I would give you, Mr. Bears, an indication of that. We would itemize the expenses, or you could argue the expenses. Either way, That's what happened here today. The civil department comes to me, says the expenses seem to be greater. They need to be itemized. And my response is let's set it for hearing, and then we'll allow the plaintiff to either itemize the expenses or to explain the expenses. Mr. Bears.
Certainly. The statute provides $5. The service was by alternate service. And the client requires a GPS location and a photo for every attempt to rebut future or potential challenges of service. So I'm getting to that screen. I'm going to find out how many attempts were made. And that is why the costs are what they are. It's
All right.
$5 for each digital photo and $10 for GPS. It's not what we charge, it's what the process server charges. It's an out-of-pocket expense that our client has to pay. And it's just a recovery of those expenses.
If you itemize that out, then that would explain to the civil department why this is why each process requires its own service. That would probably explain the differences in the cost to the civil department.
I appreciate that, Your Honor, and if we could perhaps have an adjournment of 30 days so I could get that itemization to the court, that would be great.
How about this? How about I will just await the order with itemization to follow. And then if we need a follow-up hearing, we can set that because I think we're scheduling in October right now. And so as long as I get it and we see that it's itemized, there shouldn't be any problem.
Can I say something?
Sure, Mr. Smith.
I paid the $3,900 yesterday, so I paid the agreed amount to close this case.
All right, that has to do with the underlying issue. This is more on the process service issue. So thank you for that, Mr. Smith. But this has to do with what I'm going to sign in regard to the process that's being served expenses. That was requested from the civil department, so that's why we have this hearing. But I understand that, Mr. Smith. Thank you for explaining that expense, Mr. Bears. If you're able to itemize that, we shouldn't have any issues.
Very good. I will do so. I appreciate the opportunity.
All right. So, Mr. Smith, thank you for your consideration. You should be all set. Do you have any questions of me? This actually has to do with an order of process in which the civil department was questioning some of the expenses that were being requested.
Yeah, I mean, what happened is the debt relief company I went through, I added that Capital One card to it, and for some reason, they claimed that it had a zero balance, and that's why it wasn't added. And I had no recollection that that was the case. And so the debt relief company is the one that screwed me over on the Capital One thing because they claimed that it had a zero balance. That's why they didn't include that in the rest of my debt relief program.
All right. So, Mr. Smith, you should be all set. Mr. Bears, do you have any questions of me?
Plaintiff has nothing further.
All right. Thank you. You should be all set. Thank you for your appearance today.
Great. Thank you.
Thank you. Have a good day.
Thank you. I'm just going to make a note of that. Also, all right, Mr. Burnett, we're going to bring back Mr. Collins, and then we'll call that case. All right, so we're back on the record in docket 1602321. That is LAFQ versus Aaron Collins. And Mr. Burnett, did you have the opportunity to meet with Mr. Collins in a breakout room?
Yes, Your Honor, we had a good discussion. Mr. Collins has agreed to a payment plan at this point. He's agreed to make payments of $150 a month beginning October 1st. He's going to do that every month until October 1st, 2026. And then he'll make payments at $250 a month. I did request some bank statements, or he uses Chime, and then also a copy of his vehicle title. I pointed to our address on the subpoena. So he's going to send those documents to us. We would just request a control date of the court, perhaps in October there, just to give Mr. Collins some time to get those documents to us.
Let me set the control date for the same date. So that was October. Let's look it up so we get the same date. So that would be the same date of Miss Purdue.
October 21st.
Let's set it for October 21st at 3 o'clock for control date. So Mr. Collins, please, anything that's requested by Mr. Burnett, make sure that he has that for discovery. And then we'll set it for October 21st at 3 o'clock for control date. My understanding is the terms have been placed on the record and it starts October 1st, the terms of the agreement. Is that correct, Mr. Burnett?
Yes, Your Honor.
All right. Anything else for the record in 1602321, Mr. Burnett?
That is all for the plaintiff. Thank you, Your Honor.
All right, Mr. Collins, do you have any questions of me on that file?
No, Your Honor, I do not.
All right, you should be all set, sir. Thank you for your appearance today.
Thank you.
And then, Mr. Burnett, we have we'll call it Mr. Williams. That is 96. Mr. Williams, you can come up here, have a seat. So we're on the record in docket 9601267. That's LAFQ versus Melvin Williams. Appearances for the record, Mr. Burnett.
Thank you, Your Honor. My name is Joe Burnett. I'm filling in for Tim Smith on behalf of LAFQ.
And sir, you are Melvin Williams, is that correct?
I am.
All right, thank you. This time set for a show cause. Mr. Williams is here, and so we don't have to worry about the show cause to be filed. Mr. Burnett, would you like to proceed? I can place I can swear Mr. Williams in, place him on an iPad, and you can continue the discovery. I think this came out of the discovery hearing.
It did, Your Honor. We're really just missing some documents that we requested in the subpoena. So I don't know if I need to do a full discovery.
I don't know if I think he's got the documents, but he's got them in his hand. He doesn't have them. So you'll have to mail the documents to you.
Okay. Your Honor, we were.
Or at least he can show you. I can place you in a room. He can show you. He has the documents, but you're going to need a copy of the documents.
Yes, Your Honor. If I might address the defendant, we only received 2 months of his bank statements, and we were still looking for the vehicle title. I don't know if those are the documents that he has with him.
Well, I was never told about the vehicle title. They never requested that of me, but I do have the statements and my Social Security, which you all asked for, and I mailed them. And I was told that they didn't receive anything, and that's why I was here again. That's why I brought what my taxes but I was never told of my vehicle title, because it's just an old car and it's not even running. So
Mr. Burnett, what date was it mailed on?
Oh, I was here about a month and a half ago. So it was right after that, a couple of weeks after. It was a week after that.
And you've not received any of those materials?
We have, Your Honor. We've received bank statements, but it's just 2 months. We requested 6 months. We did receive his Social Security documentation, but we were looking for the vehicle title and a full 6 months of bank statements, Your Honor. I don't know if a appropriate resolution would be for us to send a letter to him with exactly what we're looking for, and that way he knows exactly what to send.
Would that help? They'll send you a letter exactly, and then you'd know you'd have the exact materials of what to send.
Yeah. What I have here can't be sent to him through you all.
No, you have to provide that yourself through discovery. The court doesn't get involved in that.
Okay.
So what we'll do is I can set it for a control date out, and then you can provide the letter to Mr. Williams, and then he can provide the material back, and we can see where it lands control date wise, if that's suffice yet. This was a show cause motion. So there was an order to show cause for your fail to appear. That's going to be scrapped now. We're not going to have any type of civil bench warrant. I just want to make sure that Mr. Burnett has the materials.
Okay. Can I say one other thing?
Sure.
This is about a matter of a car that was repossessed in 1996,
right,
over 29 years ago. How much longer is this going to go on? Because they keep dragging me in here year after year after year for this.
It's really a collections issue at this point. Is that a fair statement, Mr. Burnett?
Yes, Your Honor.
Yeah. So yeah, they can, as long as you owe there's a belief you owe the money, you're responsible for the money. Yeah. So,
okay. So just all I need to do is just send
I would wait for the letter so you understand, so you don't want to send anything twice.
Okay.
Okay.
Right.
Is that a fair statement, Mr. Burnett?
Yes, Your Honor. Thank you.
All right. So let's set this out for control date. And we'll take that same date we've been using, October, and you're going to have to help me.
21st.
Okay, so we'll set October 21st at 3. We'll set it for control date. You can come in person or via Zoom, either way. But why we're setting out for control date is just to make sure Mr. Burnett has his discovery materials. All right, sir. All right. So we've set this for control date for discovery materials.
So I do nothing until I hear from him.
I would wait for the letter so you don't have to, so you don't have a second, so you don't make a duplicate of what you've already sent.
Okay.
And Mr. Burnett, you'll send that letter, and then we'll get the ball rolling from there.
Okay. Thank you, Your Honor.
All right. So October 21st at 3 o'clock for discovery materials. Do you have anything else on that file? 9601267, Mr. Burnett.
Nothing for the plaintiff, Your Honor.
Mr. Williams, do you have any questions of me?
No.
You should be all set, sir. Thank you for your appearance.
Thank you.
All right, and then Mr. Burnett, we have. It's Mr. Jackson?
Yes, sir.
All right, Mr. Jackson's here. It's a regular file. One file. So we're on the record in docket 1503822. I forgot to ask, Mr. Burnett, are you covering on that LAFQ file for Mr.
Yes,
Smith? All right. All right. So we're on the record in 1503822. That is LAFQ versus Leo Jackson. The third appearances for the record, Mr. Burnett.
Thank you, Your Honor. My name is Joe Burnett. I'm filling in for Tim Smith on behalf of the plaintiff.
And sir, you are Leo Jackson the third.
Yes, sir.
Thank you. This is the time set for a show cause after a bench warrant was issued It looks like it was issued and paid. I'm not sure, did this? This looks like it came out of an order to show cause. Mr. Jackson did not appear, and then I signed the order. Mr. Burnett, how would you like to proceed today?
Your Honor, I think I would like to hop in a breakout room with Mr. Jackson if that's acceptable.
It is. All right. I'm going to indicate that all parties appeared. And were you planning, was this part of the discovery hearing? I'll swear Mr. Jackson in.
Yes, Your Honor.
All right. So what I'm going to do, Mr. Jackson, is I'm going to swear you in, and then we're going to place you on an iPad. You just follow my court officer. They'll find a place of privacy for you. And then once you get on that iPad, I'm going to place you and Mr. Burnett in a room, and you can explain your discovery proceedings. Okay. All right. Let me raise your right hand. Do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
All right. Go ahead and follow Ms. Slabiak and Mr. Burnett. I bet you can go back to room 1, and then the iPad will be placed in room 1.
Okay. Thank you, Your Honor.
You're welcome. All right, Ms. Palian and Mr. Price, we're ready to go on your case. All right, so we're on the record in docket 2504036. That's LVNV funding versus Chauncey James. Appearances for the record.
Frank Price, P82598, on behalf of plaintiff LVNB Funding.
Thank you. And Ms. Palian.
Good afternoon, Jennifer Palon, P80284, on behalf of defendant.
All right, this is the time set for a pretrial in the matter. I don't know if the parties have had the opportunity to speak to one another on this pretrial. So I would give you, we have 2 lawyers involved in the matter. So you can review the pretrial, come to whatever pretrial you want. We also have a pretrial that we can just fill out here. But if you prefer with 2 lawyers involved, you can set your own time sequence and pretrial, and then you can submit it to the court. It's entirely up to you, Mr. Price.
I don't really have a preference, Miss Palin.
I would say if we want to just handle it now, that's fine. I think we'll probably just do something pretty standard, like 60 days discovery, and I'm sure you guys are going to want to file a motion if we don't handle it in that 60 days.
All right. If you give me a minute, we'll print out the pretrial form, and then I'll read it into the record, and then I'll seek authority to sign it on both lawyers' behalf. I think it's being printed right now. Okay.
Thank you.
That was fast. All right. So we're so I'm in possession of the pretrial statement for 2504036, and that is Frank Price versus appearing for plaintiff is Frank Price, and appearing for the defendant is Jennifer Palin. Pretrial was held on August 28, 2025. We have used a boilerplate kind of form saying this is a breach of contract issue. Would, Mr. Price, would you like this referred to anything else, or is it a different type of issue?
I don't think that'll be necessary in this case.
All right. So I just have breach of contract issue. Does any party anticipate any type of pleading in this case? Any further pleading? Other than the motion for summary disposition, which we hold back till after discovery usually.
Yeah, I think the pleadings are in order. Thank you.
All right, Mr. Price.
Yes, I agree.
All right. I'm not going to consolidate. There's no consolidation with cases. The admission of fact or exhibits are not applicable. We'll set a cutoff for discovery. We usually set it 90 days out, so it'll be November 26, 2025. Expert witnesses are not applicable. Damages have been pled for. There's no joinder of claims. Mr. Price, have you paid for a jury trial fee, or do you expect this to be a bench trial?
I am not exactly sure, Your Honor.
Yeah, it's a bench trial. That's fine. We didn't pay for anything either.
I don't think there's been, at least at this time, as there's been no payment for a jury trial. Is that correct, Mr. Price?
That's correct.
All right. So that'll be set after discovery closes. Possibility of settlement negotiations are to continue. I have not set this for case evaluation or mediation unless a party requests. Mr. Price, are you indicating that I should set this for case evaluation or for mediation?
No, we don't want it. We're not requesting a case evaluation on this one.
All right, Ms. Palin.
Yeah, same. We work together a lot, so we'll get it resolved one way or the other.
All right. All right. So, Mr. Price, I have your authority to sign this. Really, we've done. We've kept the motions for summary disposition and response, and we've set discovery on November 26, 2025, which are 90 days out. That's the sum and substance of the pretrial statement. Do I have your authority to sign this via Zoom?
Yes, Your Honor.
And mine as well. Thank you.
Thanks. All right, I will sign this as the sitting district court judge for 8/28. And that'll be the pretrial statement. We'll sign and scan it and provide a copy to both litigants for your records. Anything else for the record in 25-04036, Mr. Price?
Nothing for me, Your Honor.
Ms. Palin, do you have any questions of me?
Nothing here. Thank you, Your Honor.
All right, you should be all set. Thank you for your appearance, both of you.
Thank you. Real quick, Judge Flores. I know we got people waiting, but you were my evidence professor in
Was I really?
Yeah, 2016 or 17, somewhere in there.
I hope you learned something.
Yeah, I definitely did.
All right,
awesome.
thank you, Mr. Price.
Yep,
It's good to see you.
Good to see you too.
that here, and we'll bring you up here, Mr. Jackson. 1615. All right, Mr. Jackson, you can come up here. All right, so we're back on the record in docket 1503822. And Mr. Burnett, did you have the opportunity to speak with Mr. Jackson in a breakout room?
Yes, Your Honor. We had a good discussion. Mr. Jackson has actually agreed to a payment plan. He's agreed to pay $150 a month beginning October 1st and make those payments every month until paid in full. I did request a certain number of documents from him that were in the subpoena. He's agreed to put those together for us too and send them our way. As with the last case, Your Honor, I would request a control date. And of course, we can use that same one in October, I think would be appropriate. I think the last thing is Mr. Jackson's bond. We would just ask that it be forfeited to the plaintiff.
All right, so we'll create a slot because I know you're here that date for two other cases. So on October 21st, we'll set that for control date. I think that's at 3 o'clock or 3:30. 3 o'clock. All right, and then for the record, I'll indicate that the bond that has been posted will go to the plaintiff in the matter. And I might need an order post for the bond to go to you, but I'm not sure, Mr. Burnett. I'm not sure how that works because that's the civil realm of things. But I've written in the Register of Actions that any posted bond would go to the plaintiff.
Okay, thank you, Your Honor.
All right, so we've set a control date for October 21st at 3 o'clock. Anything else to the record on that file? 1503822, Mr. Burnett.
That is all, Your Honor. Thank you.
All right, and I've got a couple failed to appears that we should call. Mr. Jackson, do you have any questions of me?
No.
You should be all set, sir.
All
Thank
right,
you.
thank you.
All right, so while I've got you here, let's go on. 22. So that is 22-01352. That is LAFQ versus Taisha Vickers. This was set for discovery. Appearances for the record, Mr. Burnett.
Good afternoon, Your Honor. My name is Joe Burnett. I'm filling in for Tim Smith on behalf of the plaintiff.
All right, this was set for 1:30. It is now 3:04. It would appear that the defendant has failed to appear for the discovery hearing. I do not see Ms. Vickers in the Zoom courtroom. There's nobody in the physical courtroom, and there's nobody in the hallway. So it appeared that the defendant has failed to appear for discovery, for the discovery hearing. Mr. Burnett, how would you like to proceed?
Your Honor, we would request leave to file a motion to show cause against the defendant.
Motion to show cause. Okay. So we will allow the I think it's a 9-day notice for the civil for order to show cause, and then we'll set the show cause hearing to that effect, and you'll provide that an order to follow for the show cause on Ms. Vickers for her non-appearance. Is that correct, Mr. Burnett?
Yes, Your Honor.
All right, so that's all for the record in 22-01352. Then we have we have 16-01798. That is LAFQ versus Ajayi Perkins. Appearances for the record, Mr. Burnett.
Yes, Your Honor. This is Joe Burnett. I'm filling in for Tim Smith on behalf of LAFQ.
All right, this is the time set for a show cause motion for the non-appearance of Ajay Perkins. It would appear that Ajay Perkins, this was scheduled for 2 o'clock. It is now 3:06, and the defendant has failed to appear for the show cause hearing. I do not see Ajay Perkins in the Zoom courtroom or physical courtroom, and nobody answers by that name in the hallway. Mr. Burnett, it would appear that Ajay Perkins has failed to appear. How would you like to proceed?
Your Honor, we would request that a bench warrant be issued for Ms. Perkins. The balance on her account today is $1,023. We would ask that the bond amount be that balance, but I understand that, of course, it's the court's discretion on a bond amount.
I will issue a bond. Make sure the request for the 1,000, she'll be usually on a civil. I think they're PR'd after 4 days. Yeah. So, but so I will accept the show cause order with the bond amount for the debt of 1,023, and that order is to follow. Is that correct, Mr. Burnett?
I just want to clarify that would be for issuing a bench warrant, Your Honor.
Yes, for issuing the bench warrant for 1,000 for the cash amount, cash or surety of $1,023.
Yes, Your Honor.
All right. So that's all for the record in 1601798. And then I have a last case. I get confused when they give me paper files and then they give me electric files. So this is 0703596. This is Lafque versus Jennifer Trudeau. Appearances for the record, Mr. Burnett.
Yes, Your Honor. My name is Joe Burnett. I'm filling in for Tim Smith on behalf of the plaintiff.
And I have this is the time set. 1:30 was set for the motion to show cause. I do not see a Jennifer Trudeau here. There's nobody by that name in the Zoom courtroom or physical courtroom, and nobody answers by that name in the hallway. This is for a non-appearance for June 25th. And it would appear that this is scheduled for 1:30. It is now 3:09. And the D1 has failed to appear for the show cause hearing. Mr. Burnett, how would you like to proceed?
Your Honor, I think we would request a bench warrant today due to her failure to appear. For full disclosure, it does look like Mr. Smith did have some communications with her a few weeks ago. She told him that she missed the initial date because of a surgery. But for what it's worth, Your Honor, we didn't necessarily release her from appearing today, Your Honor. It was still our anticipation to have today's hearing.
Well, we've had no contact with Ms. Trudeau concerning any conflict or any procedure. So at this time, I'll issue a bench warrant, civil bench warrant. And what is the amount that is being collected on?
The balance today, Your Honor, is $2,459.
All right, I'll set bond at, so you can request, I'm going to set bond at 1,000 cash surety.
Okay.
All right, and so I'll await the order to follow concerning that bench warrant. Anything else for the record in docket 0703596, Mr. Burnett?
That is all, Your Honor. Thank you.
All right. I think we're all set, Mr. Burnett. Thank you for your appearance today.
Yes, thank you, Your Honor. I'll see you again.
All right. We'll see you soon.